Thank you very much, Chairperson. Chair, I believe Action SA's position is on the record already in that I wrote to you and the Speaker in this regard, but I want to put it on the record in this meeting. First of all, we note the deadline of responding by tomorrow. So thank you very much for convening this meeting today. We believe that the urgent interdict must be opposed. This matter is not urgent. It's 4 years old. And we, as a committee, have been cited through you as our representative. So we've been cited and we must oppose. I want to remind the committee that this matter is before us because Parliament balked previously from doing what it should have done. And the Court is functus officio in this matter. And it has issued a final order that Parliament must do what Parliament must do. And the only way that can be stopped is that if there is any malafides, fraud, or corruption, to empower an interdictory relief. And I don't believe there is or there are any malafides, fraud, or corruption in this matter. Also, Chairperson, the Concord judgment is not appealable. And a lower court can't stay, vary, or rescind a constitutional court judgment as per the opinion we've received and mentioned in section 18, that it may not competently displace a constitutional court order. Chairperson, if we do not oppose this, Action SA believes it would be tantamount to this committee self-emasculating or neutering itself. The Section 89 Impeachment Committee has got specific and very special work to do. And we as Action SA will have no part in any exercise that serves to emasculate this committee. It's one of the most important committees of Parliament, and we need to defend Parliament in every instance. And also we need to defend the Constitution and also the institution of the presidency. So I believe it's imperative and incumbent upon you, Chair, to oppose this interdict, which is not urgent. Thank you.
Thank you very much, Honorable Trollip. Let me just check once again. I'll come to you, Honorable Swart. Let me check Honorable Khatib of the IFP, if maybe your network is back on. If you can hear me, you can come in if you are there. There's no response from the IFP. Checking once again for Honorable Vessels of the Freedom Front Plus. Can you hear us now? And can you state your position? There's no response. We then move. ACDP, Honorable Swart.
No, thank you, Chair. Chair, we addressed a letter from the ACDP side to the Speaker, reminding the Speaker and yourself of the Constitutional Court's ruling at paragraph 94, where the court said the National Assembly's oversight role over the President lies at the heart of our constitutional scheme, and accountability of the President is one of the foundational values of our Constitution, and the National Assembly bears the responsibility to ensure that the President is held accountable. We also said this is unprecedented as an impeachment process, and every step of the process must be carefully considered given the precedents that it creates. Now, Chair, the Senior Counsel made it very clear in paragraph 32. It says, in this context, the IC's compliance with the Court's order is not optional. It is a legal and constitutional imperative. The IC, that is us as a committee, cannot suspend its compliance pending the outcome of litigation in a lower court. The IC must proceed with its work and defend its right to proceed against any attempt to interdict that compliance. Chairperson, it is very clear, and that's why I wrote my letter on behalf of the ACDP, pleading with the Speaker to oppose the application, as well as you as Chairman of the committee. What is also important is the point ACDP raised about the time should there be appeals raised, and that brings Rule 129M, which says this process must be finalized within a reasonable time frame. It also brings Section 237 of the Constitution, that our constitutional duties must be fulfilled without delay. Chairperson, other speakers have indicated the public are demanding to know what happened. Now, not in months or years' time, should there be appeals to the Constitutional Court. And Chairperson, it's important to note that the President could have approached the Constitutional Court for a stay of its order. He chose to approach the Western Cape High Court, which in our view, which is substantiated by the Senior Counsel, does not have jurisdiction over this matter given the Constitutional Court's ruling. So, Chairperson, with that having been said, we strongly urge both the Speaker and this committee to actively oppose the interim application. Thank you, Chairperson.
Thank you very much, Honorable Swart. UDM, Honorable Nkwakwa.
Thank you very much, Chairperson. I'm glad that Honorable Steve Swart has quoted directly from the Concord Order. The Concord Order states it clearly that it's the National Assembly. I want to state the point that we are of the view that by citing you, we are being sent on a wild goose chase by expecting us to challenge matters that we can't do in our own right. Let me state a point clearly, Chairperson. We cannot be established by Parliament, constituted in terms of its rules, and then be expected to operate independently of the very same institution that created us, to which we remain accountable. It is not correct. I listened to the sequence of events. The committee was not established by the Concord, it was established by Parliament. We were guided even back then by the Concord judgment, which said you can't deal with the motion of no confidence the same way that you deal with the impeachment process. We had to set the bar higher. Those were part of the debate. In 2022, December, will remember that was the main crux of our argument when we're saying do a secret ballot speaker. So if Parliament is the source of our mandate and authority, it is therefore, in our view, legally and constitutionally untenable to suggest that a committee can function as though it was separate from the institution that established it. You will recall, Chairperson, that we are here because of Section 57 of the Constitution. It is Section 57 of the Constitution about dealing with internal arrangements of Parliament that gives the National Assembly, because that section deals exactly with the powers of the National Assembly, that it can delegate its work and it will do it via committees. We are one such a committee. So we should not, when we discuss the question, which is very important, of independence and impartiality, assume that it's independence to say that institutionally we're independent of Parliament. No. The independence that is being referred to here is impartiality, as the people who are going to make sure that we hold the President to account, right? So that's where we are. So the Constitution, if you look at section, I'm not a lawyer, you'll forgive me, but that's my understanding, and our understanding is that it envisages that Parliament as the central locus of political accountability. Parliament, with its committees serving as mechanisms through which that accountability is exercised, rather than us seeing this committee as being completely independent. In essence, what am I saying, Chair? What am I saying? What are we saying? We're saying yes to us holding the President accountable, but rather challenging the interdict. But perhaps what we should do is to do it via the correct processes, where it's not the committee itself, but we do it via the Speaker. The Speaker is the authority of the national, exercises that authority on behalf of the institution. I want to remind colleagues, when during the Zondo Commission of Inquiry, we had a problem when Speaker was Thandi Modise. One of the complaints we had as the institution is that the Zondo Commission kept on writing to individual members of parliament and portfolio committees without addressing the institution directly. And that was our gripe. I was requested to go there and testify. I said, on the basis of what? I can't be called as Ngabamzi Kwangwa when I exercise my authority in a portfolio committee on behalf of parliament as an institution. So yes, indeed, let's challenge it, but do so via parliament. I do believe that as this committee, once we have reached a resolution that says we want to challenge and we instruct the speaker, there should be no reason for the speaker to say she can't do that when we are exercising that independence and impartiality and trying to get the president to account to parliament or to this committee on behalf of the National Assembly that elected him into office. Thank you.
Thank you very much, Honorable Kwankwa. Bossa, Honorable Imani.
Thank you, Chairperson. I think without trying to repeat what everybody else has said, firstly, I think as Build One South Africa, I'd affirm the view that we must oppose the interdict, fundamentally because I think on what the establishment of law, the establishment of the supremacy of parliament, but thirdly, the precedent could be devastating for future processes. The legal counsel has already stated to us that this process must be fair and defend the rights of all parties, including the president, by the way, and the rights of parliament. Therefore, in that light, if we fail to appeal this matter, we would then set up a situation where in future, another member of the executive faced with similar or different circumstances could be reliant on saying, I could interdict the work of parliament. And I just think that that is wrong, just not only in terms of this current case, but it is wrong in terms of the constitutional arrangements as to where the executive accounts. The second matter is simply that, Chairperson, that an appeal, as another honorable member stated, does not pronounce guilt on the part of the president. Our job is inquisitorial, as the legal team has already stated. Therefore, I would urge that, in fact, the committee must then deliberate further on its own program and figure out what it needs to do. Thirdly and lastly, Chairperson, I hold the absolute view that I was not completely dissuaded by the legal counsel that a declarator from the Concord should not be sought. And that can be done, as Honorable Kwankwa stated, this of appeals, etc. So I still maintain that through the Speaker, I'd like to inquire, or through you, Chairperson, whether or not an application to the Concord for a declarator, given that all of these legal matters are coming through on both the application and the interdict, must be sought so that we don't end up with extended delays. I really believe we need to get to the business of the work so this matter is behind us. I maintain that we are best served as South Africans by getting over this matter so that the president can focus on the work and the duty at hand, which the matters of South Africans are complicated beyond this issue and need everyone's focus. So may I request that question be addressed through the Speaker's legal counsel. I would appreciate that. Thank you very much.
Thank you very much, Honorable Maimane. We now move to the ATM, Honorable Zungula.
Thank you, Chair. Firstly, we are in this process because of a constitutional court order, which was very clear when it comes to how we should proceed and the manner in which we must proceed. Therefore, we can't then accept that an entire head of the state would want not only to undermine Parliament, but also undermine that particular Concord order and in effect undermine the Constitutional Court, because this process is a result of litigation that was adjudicated by the Concord. So to seek to interdict Parliament violates the constitutional obligation of Parliament as espoused in Section 55 of the Constitution of holding him accountable. It also violates the separation of powers principle, also violates the constitutional court and in fact the entire state therefore. So in that, Chair, I want to move that the decision we must take today must be to defend the independence of Parliament and for Parliament to dictate or to direct its own programs and processes. So we must oppose. The second issue I want to raise is that precedents when it comes to the Section 194 process, which dealt with the impeachment of Advocate Mkhwebane, the Speaker, as the head of the institution, as the head of this legislative arm of the state, went to court to oppose Advocate Mkhwebane's interdict. So we must be principled as Parliament to say it must be the Speaker representing the institution. We must not create a case where it might appear as if it is only this independent, this impeachment committee that is opposing, and the institution, is fine with the application to interdict the process. This process must be defended by the Speaker of Parliament, as she is the head of the institution. That is, Chair, I think the most important thing that we want to highlight. I don't know how, given the fact that the meeting and the deadline to oppose, to file a notice to oppose is tomorrow. But like have done now, we can make even the virtual meetings in the forums of other forums of Parliament. But if I can advance, Chair, that if we frame our resolution to say we are taking this resolution as the impeachment committee, but due to the issues of principle and precedence, we advance that opposition must be done by the Speaker of Parliament. Thank you.
Thanks very much, Honorable Zungula. NCC, Honorable Adams. If you're still on the call, I know that you're about to board. All right, looks like not in the meeting. Honorable Musa Al-Jama.
Thank you, Honorable Chair. Al-Jama, in the interest of fairness, transparency, and legal certainty, our party is of the view that the committee should ensure that an independent second legal opinion is obtained before any final decision is taken. And our party is of the view that presently the present president should apply for a stay of order. And to the extent that the president get a second opinion by challenging the High Court report. I thank you so much, Chairperson.
Thank you very much. UAT, Honorable Matafe.
Thank you, Chairperson. Chairperson, I think at the heart of this matter lies the doctrine of separation of powers. Now, the Constitution entrusted the National Assembly with the solemn responsibility of holding the executive accountable. Now, this process is then one of the most important accountability mechanisms available to Parliament. To prevent the committee from merely commencing its inquiry will be to frustrate the Parliament constitutional oversight function before any evidence has been tested. Now, because the committee has been cited through its chairperson, which is you, sir, I also support that the committee must oppose the interdict application purely on legal principle, as had been stated by Dr. Hlophe. Chairperson, I submit.
Thanks very much. Before I call on the DA, checking for the final time, IFP. No response. Final time, Freedom Front Plus.
Thank you, Chair. I'm covered. Nothing to add at this stage.
When you say covered, is that the oppose or covered abide?
Chair, I agree that we should oppose. Yes, I agree that we should oppose.
Thanks very much. Thanks very much. Now go to the DA.
Thank you, Chair. Good morning to everyone again. Chairperson, our view is this, that we lobby the Speaker very vigorously to oppose this application for an interdict, because the work of the committee must proceed. And until there's an interdict prohibiting us from going ahead, we must go ahead, and no delay should be countenanced. However, I disagree quite sharply that the committee can do it, Chair. Legally speaking, in my view, a Section 89 Impeachment Committee does not have locus standi to litigate in its own name. The committee is an extension of the National Assembly and lacks distinct or separate legal personality. The committee derives its powers entirely from the Constitution of the Republic and from the rules of the National Assembly. And we are established to assist Parliament in carrying out its constitutional obligations. Legal action is required to be instituted or defended by the Speaker of the National Assembly, and it must be done in her name as the juristic entity. So, Chair, I don't think that we as the committee can litigate on our own behalf, but the committee should, in my view, take a decision to vigorously lobby the Speaker to do so. Thank you.
Thanks very much. And finally, the ANC.
Thank you very much, Chairperson, and greetings to yourself and other members, and congratulations again. The first issue is that we're not convinced about the independence of the committee to can litigate or oppose or abide by itself. It is a creation of the National Assembly, which is Parliament, and it is created with a constitutional duty to conduct its work fairly and impartially, not independently, impartially. I agree with Honorable Kwankwa that the reference of independence was solely to cover impartiality. But given the fact that the President has approached the courts, we think that the committee should respect the judicial process and abide by the court's determination. The committee's role is not to defend the Section 89 panel report, but to conduct an objective inquiry. Should the court permit the process to continue, by abiding, the committee protects both the separation of power and the integrity of its proceeding. So we are taking a posture that we should abide, Chairperson, and in doing so, we must file an explanatory affidavit, as the SC has said. The explanatory affidavit must stay far, very far, and clear of the merits and demerits of the case in point, so that we maintain the impartiality of the committee. We would want the committee to engage the Speaker, that she be the one doing the opposing if the committee agrees to oppose, or abiding if we agree to abide, not this committee, because we believe that this is a creature of the National Assembly. Thank you very much.
Thank you very much, members. I just want to check if there's any member of the parties that wants to state a different position from that that has been stated by the principal representative before I sum up the discussion and the recommendations of the parties.
Chairperson, sorry, Chair, I put up my hand. I do not want to agree with the position that I put. I agree fully. I just want to get clarity from you, Chair, when you wrap up. You have been cited as a respondent. Can you give us clarity on your position and what you will be doing as a respondent, as the chairperson of this committee, who is our nominee? You are the nominee of this committee and you've been cited. You need to tell us how you're going to deal with that, especially in light of the two submissions made last, that the committee doesn't have locus standi as per the DA, and the ANC says that we should be asking the Speaker to respond on our behalf. So I think we need you to clarify that position. Thank you, Chair.
All right, can I please ask the hands to be taken down for now, so that we can have a new set of hands if there's any new set of hands. Honorable Ngitama, is that a new hand, or you are going to contribute to the discussion? Or you want to take a different position from the one that has been stated by Honorable Shope?
No, sorry, Chair, it's a legacy hand, so.
All right, thanks. Honorable Mkhalakis, is that a different matter before I sum up the conversation?
Thank you, Chairperson. Good morning to all of you. Chairperson, it's a new submission, or just to add on. Chairperson, I want to just indicate one or two things. The first one is, I want to go back to the original role of the Speaker, and I want to perhaps just, if the committee will indulge me, quote, perhaps from another place, Speaker Lenthal, who said, "I have neither eyes to see nor tongue to speak in this place, but as the House is pleased to direct me, in whose service I am." That is a very, very old and ancient quote of the role of the Speaker, who is in service of the National Assembly and whose sole prerogative and job is to ensure that this place is able to fulfill its function. Now, Chairperson, the Interdict application itself is directed at preventing this House from fulfilling its obligation, which the Constitutional Court has given it. My submission is that we are not just an idle bystander in this application, but it affects Parliament very directly, and it speaks to the role that Parliament must fulfill in terms of the Constitutional Court. My submission to you, Chairperson, is that the Speaker's role in all of this is to function in a way in which the House directs her to function. So my request to you would be that if this committee today, and it should, if this committee today decides that this needs to be opposed, that the Speaker should act on our instruction and oppose the application. And I want you to please keep that in mind when you answer the question of Honourable Trollip, which is a very valid question, in how your role, how you fit into this equation. The Speaker has an obligation to act on the request and the instruction of this committee. And I would therefore implore you to convey that instruction that this matter needs to be opposed and that the Speaker should act as our representative in this application, but that she should act in line with the wishes of this committee, which is to ultimately oppose that application. Thank you.
Thanks very much. So that I don't want to invite so many hands, just to check Honorable Daniels, Honorable Zungula, Honorable Malema. Is it matters of emphasis that you want to put, or you are supplementing the inputs that you had made? Honorable Daniels, just a quick one.
Thank you, Chairperson.
I'll give you a minute. I'll give each one a minute so that we move towards closure.
Thank you, Chairperson. Thank you, Chairperson. Chairperson, I'm not moving from our position that we must not oppose. The opinion, Chairperson, advises the committee both to maintain strict neutrality and to actively oppose the interdict. That's opinion. While conceding in paragraph 44 that the committee may instead file a notice to abide. Now, having said that, I want us to appreciate that this is nothing more than just an opinion. And I'm sure if we source an opinion from a different firm, we may come with a different opinion. And I want you to consider, Chairperson, before you take your final determination, that maybe to get another opinion, because one opinion is not necessarily law, but just as a guidance. And I firmly believe that for you to apply your mind, because the question asked by Honorable Trollop is going to lean to just, we cannot be bounded by this one single opinion, Chairperson, because it already contradicts itself.
Your minute.
Thank you, Chairperson.
Honorable Zungula, 1 minute.
Thank you, Chair. Firstly, let me deal with the question whether the committee has got local standing to oppose. The answer is yes. That is what the legal opinion says. Secondly, there is precedence in that in the Section 194 committee that dealt with the impeachment of Advocate Mkhwebane, the chairperson at the time, Ukubutile Janji, opposed all of the cases and the interdicts that was filed by Advocate Mkhwebane. Therefore, even with this committee, we should oppose. This committee should oppose, and also including opposing, we must petition the Speaker to oppose on behalf of Parliament. We need to be the ones that protect the committee to be able to do its work. And Chair, we can't then be wanting to do many other opinions. Like the deadline to institute or to file an intention to oppose is tomorrow. Now we must have another opinion and then discuss, and then another person will say, no, let's have another opinion. No, Chair, let's just
Thank you, Honorable Zogola. Your minute is up. Honorable Malema, 1 minute.
Thanks, Chair. I think that even the President knows that we have a duty, if we so wish, to participate directly as a committee. And it will not be naive or stupid of a president to cite you if we had no role to play. There is a precedence Honorable Zungula spoke to. The principle is we must oppose. The nitty-gritties of it, you comrades can deal with it at that level. But the principle is that we're opposing and you're going to have a discussion. Obvious, you cannot just oppose without having a discussion with the Speaker. And she can as well just say, no, look, let's do one thing. I will oppose this thing and then proceed in that way. If she has got a different view, you proceed on your own on behalf of the committee. It happened before where the committee responded to an interdict of impeachment. It's not for the first time. And to be asked to just look at opinion as an opinion, exactly what the courts have warned against. It's an opinion, yes, but you have to have good reasons why you are ignoring that opinion. You can't just say it's a mere opinion. That's what they said about the panel report. And that's why we are where we are now. Really, we cannot go back there. Let's oppose, and you are going to oppose on our behalf.
Thank you, Honorable Malema. Your minute is up. Honorable Direko, a minute. Honorable Direko.
All right, thank you, Chair. Thank you, Chair. My apologies, my network is a bit bad. Chair, I want to also emphasize that as members of the Impeachment Committee, we have a responsibility to ensure that the process is fair, objective, and credible. For this reason, I believe that the committee should abide by the court process rather than being actively opposing the interdict. The reason why I'm saying that is that our role is to conduct a fair process, not to defend a report in court, which is not even our report. So if we actively oppose the interdict, we then risk creating a perception that we have already taken a position on the matter. So I then support what our whip has just said, that let's rather abide by the court and ensure that the process is fair. We are not seen being taken aside or being on the other side of that of the other people. Thank you.
your minute is up. Honorable Nola, 1 minute.
Chair, I see no compelling legal reasons why we should aggressively go for a fully blown opposition to the application. Worst of it, Chair, is us who are raising serious issues, critical issues of the jurisdiction of the High Court, and our backbone is the decision handed down by the Chief Justice in the Apex Court. So the law is already still on our side. So I think it is important that we file a notice to abide with a declaratory affidavit where we advance the legal principles that we agree upon here in this meeting. So that's what I think we should do, Chair, without going fully blown on opposition. For that matter, Chair, we're not interdicted now. We're still going to do our work, doing the terms of reference, appointing the evidence leaders and all that. We are still going to do that work. In the meantime, no one has interdicted us. But I think because we are comfortable, but that the law is on our side. So let's allow the courts to give us that question.
Thank you very much, Honorable Nola. Your minute is up. Honorable Dagmar, 1 minute.
Thanks again, Chair. Just to amplify the points made by Honorable Plauli, Direko, and Mola. The issue is that we, using language such as vigorously oppose, begins to undermine the critical need for us to be impartial. So I support that issue, but also want to specifically say that we have a chair of this committee, we have a speaker, both have been cited. I want to propose formally that there needs to be an engagement between the chair and the speaker. It's a serious concern if we're going to have no consultation given arguments that have been raised before. So I propose that once the committee has a view, the chairperson needs to represent us in an engagement with the speaker. Thank you.
Thank you very much. Honorable Khafau.
Nakenza Mhlamashtulo. There is nobody here who should be confused about our responsibility to defend our existence. Our existence as the Impeachment Committee is mandated by the Concord. The National Assembly has given us full powers to exist. The rules around our existence have been adopted. So whether or not the President of the Republic does not like our existence or is trying to find ways around whether our existence must exist or not, that's not an us problem. And therefore it would be incredibly irresponsible of us as the Impeachment Committee to sit back in a fight that seeks to nullify our existence. So our job is clear. We must proceed with the impeachment proceedings. We do not need to wait for the Interdict to decide on our behalf. We can have a say ourselves to say we are constitutionally mandated to continue. If you're saying we must not continue, we say we must continue. And there's nothing wrong with being legally in court on record saying that. So it is important that we oppose the Interdict. Thank you.
Thank you very much. I have 4 last speakers, and then after these 4 speakers, because I'm not hearing any new addition rather than the emphasis of the points that have been made before. So the last speaker will be Honorable Mautwe. So I'll now go to Honorable Musa, Honorable Nitama, Honorable Maimani, and then the last speaker will be Honorable Mautwe, and then I will sum up the conversation and answer the question that has been asked in terms of the decision. Honorable Musa, your minutes.
Thank you so much, Honorable Chair. The committee should exercise its right and mandate to a second legal opinion. We're dealing with the President, and I think it is important in terms of the national interests of this country that we exercise our right and ensure that a second legal opinion is sought. I am strong of that view. Thank you so much, Honorable Chair.
Thank you very much. Honorable Nditama, your minutes start now.
Thank you, Chair. Chair, the proposal for another opinion is practically impossible at this stage. We have the deadline to meet. But I want to emphasize also that this committee must on its own right oppose the matter. because if this matter, we don't even know what argument the speakers is likely to take the line of her position. So we here have a responsibility to protect the integrity of this process and take much more seriously the responsibility given by the Constitutional Court. Therefore, Chair, I do strongly suggest that we oppose this matter in the name of this particular committee so that we move and resolve this matter. Thank you.
Thank you very much. The last speaker is Honorable Mautu.
No, Chairperson, you've skipped me.
Oh, sorry. The hand kind of disappeared, Honorable Maimane. I thought you were covered. Honorable Maimane.
No,
Honorable Kwankwa, I had closed the speaking list, unless it's a point of exigence. Honorable Maimane.
Chairperson, the legal team that was on this call made it clear we have been invited to a fight. Therefore, the question of whether the committee can oppose in its own right is established on the principle of being cited through you. So I think for us to debate, I take the comments about the speaker, etc. I would argue that we need to respond, we need to oppose, and ultimately the work of the committee must continue, because, Chairperson, for us to delay this matter and not want to file a response and wait for another opinion will in fact undermine the work of this committee. We will going around on these issues over and over again in courts all the time. And I reaffirm, let's get a declarator and get the work of the committee on the go. Thank you.
Thank you very much. Honorable Mautwe.
Thank you very much, Chair. Chair, one, we need to oppose in line with the legal opinion that you sought on behalf of all of us. We can't sit and just wait and be bystanders, because the interdict seeks to hold the work that we need to do as this committee. And this SC went at length to explain the legality of it and what will be our legal basis on it. So there's no debate about it. Number two, Chair, the deadline for us filing the papers is tomorrow, so there's no need for us to seek a second opinion. It's a waste of time, it's a waste of money, the resources, the little resources we have as a country. And Chair, the last one is, we doubt the speaker, and we should actually come out as this committee with a resolution that says the speaker must oppose, because we have already written as the EFF to the speaker to oppose. The ACDP earlier on did indicate that they wrote to the speaker to oppose. I think even Action SA did alluded to that fact. And she's not doing anything. And therefore the resolution by this committee is that she should also oppose. Thank you, Chair.
Honorable Kwankwa, I'm giving you 53 seconds.
You can't. Kalok, remember that was the submission of the party. Now I must state whether I agree with it or not. I'm kidding, Chair. I think there's a third way here that Honorable Malema has proposed, which I agree with entirely, because the question is, it's either we say we have two options, either the speaker or the committee opposes. Now we're saying let's have a resolution that is firm enough on this question that you will take to the speaker and have a discussion with the speaker. In the event that the speaker does not oppose, the committee should oppose, so that we don't sit back and twiddle our thumbs and do nothing and be helpless because the speaker has not moved on the issue. I think to us that is a very good way forward.
Thank you very much, honorable members, and thanks for the inputs, the points that have been made, the prevailing opinion based on the inputs that have been made by the parties is that the committee needs to oppose the urgent application of an interdict by the president. So that is the prevailing opinion of the committee. I don't even need to put it to a vote. The numbers are such that those that are on the side of opposing, it's they are in the majority. To the question that was asked by Honorable Trolip, so I, as the chairperson of the Impeachment Committee, align myself with the prevailing opinion of the members of this committee that we should oppose the application, and I will do so on behalf of the committee. So it will not just be me in my individual capacity, because I was not cited in my individual capacity, but as a chairperson of this committee, I intend to represent the committee in opposing the interdict application by the president, and as it was proposed, will then petition the speaker to also join in opposing this application. But if the speaker decides not to oppose the application, as the chairperson of the committee and the second respondent to the interdict application, I will represent the committee in opposing the application. The view in terms of seeking a second legal opinion, given the time that we have, that we need to indicate by tomorrow, I don't think it will be, we'll have enough time to be able to get another opinion, still have another conversation. So the prevailing view of opposing that stand, and that's what I'm going to file on behalf of the committee, start working with the legal team. And if there's a question, one of the questions that might very well need to be answered, and we'll try to get it answered, it's whether as a committee we can adopt or we can oppose if the speaker decides not to oppose. But given what the legal opinion that we have received, I think we are on a good footing in that regard. But I will still petition the speaker to join us in opposing this interdict. That's the prevailing opinion of the committee, and is that going to be taken forward by the second respondent to the interdict, which is myself as the chairperson of the committee. So that concludes the discussion on this particular matter. Just to indicate, honorable members, that the work of the committee has not been interdicted. It continues. We will have our meeting next week on Wednesday, the 24th of June at 10 o'clock, where amongst others we are going to consider our draft terms of reference and also the process to appoint evidence leaders. I have said this when I was elected, that we are going to focus on the things that are in our control. What's in our control is to get the process on the go. The things that are going to happen outside of our control, we are not going to focus on them. We'll continue with the work of the committee until being asked or told to do otherwise by a court of law. So until such time, we are proceeding as the impeachment committee with our preparatory work, and we will see each other next week, Wednesday, in person, 10 o'clock at the Good Hope Center. Thank you very much, honorable members. The meeting is thus adjourned. Councillor Snell.
Hey, Councillor
Chair. Oh, Simsha, my stool.
Can say.
I can't,